Hello, welcome to today's immigration tidbit. Okay, first, the answer is legally you can apply. There's no problem with that. The issue is whether it'll be granted. So, you have to look at what the law is for a B2. A B2, which is a visitor visa, the law says you intend on staying here for the rest of your life with no intention of wanting to go back. That's what the law says. And you have to prove them differently. Okay? You have to prove that in fact you do intend on going back. So now that, depending where you're from, in some countries that's harder than others because of the violation rate once people get here. However, it's hard enough to do that without any roadblocks in the way to start. Now, if you have an F2A preference, that means you have a family petition. That means you eventually want to apply to get the green card. So that definitely is a roadblock, and that definitely is going to make it more difficult to believe that you intend on just visiting and going back to your home country, even though you've been petitioned on an F2A preference. So what you have to do is you have to look at the time, more or less, of when the visa number will be current. If, for example, it's going to be current in 6 months or a year, there's no way you're going to get a B2. Absolutely no way. They know what you're going to do. You're going to come here and then you're just going to adjust status and get the green card. But let's say, just for example, let's say that the preference date is 5-10 years away, give or take. In that case, it's much more probable that you'd have a good argument to make that you could say, well, yes, in the future you intend on becoming a lawful permanent resident and you intend on staying here, but for now you just want to go visit your family and then you want to go back to your home country, continue to work, do whatever you do, show you have assets and so forth. And that's how you could do that and still have an F2A pending. Okay?